So once you've created the brand, then you have to protect it. And there's a couple ways to protect it. One is you have to protect it legally. And in this country, being the first to use a brand name in business gives you the right to that brand name, period. Even if you don't register it, the fact that you have used it in business gives you the right to that brand name. If you want to claim legal protection, you need to register it with a trademark or service office. That can be done either at the state level or at the national level. And again, we talked about the U.S. Trademark and Patent Office website, very easy to use. And if you have been using the name in commerce and somebody else applies to use that name, then you can challenge it. And I have my friend I'm going to visit next week is a intellectual property paralegal for Activision, and that's his job, is to monitor the trademark filings, and anytime anybody publishes or asks to use the right for a trademark that might infringe on one of the trademarks from Activision, it's his job to call that to people's attention and say, no, I don't want to do that. Infringement is where you use a trademark without authorization. And it has to be used in a way to cause confusion. I'm trying to think. So if I wanted to sell Budweiser wine, don't know that, because Budweiser is a well-known trademark in the beer. And would that be confusing? But if I was going to say Budweiser Housing Development, Budweiser Apartments, is there any chance that anybody's going to be confused that my apartments are associated with the beer? So that probably wouldn't be infringement. Again, that's where the trademark comes in. The way that it works is the government does not monitor whether or not people are using your intellectual property correctly. That's your job. That's why my friend has a job. And you need to call it to the government's attention that somebody is infringing. In that case, we can start legal proceedings against the person who has done it. Usually starts with a cease and desist. I have here one of my, I just love this logo. Have you seen this one before? Is this like the scariest logo you have ever seen in your whole life?
It looks like currency.
It looks like what?
Currency.
It looks like currency, but it looks like currency from the Third Reich. This IPR Center, stealing intellectual property is a crime, and we will tear the flesh from your bones if you copy this movie. Every time I see that, I just go, oh, I'm so scared. But again, if you hear the stories like, the little daycare center paints Donald Ducks on the wall, and then the evil Disney Corporation sends them a cease and desist letter, says that you can't paint Donald Ducks on your wall without our permission, and people are going, oh, the evil corporation is taking it. The point is when you find somebody is using your trademark without your permission and you don't do anything about it, then you risk that falling into the common domain, or to just the fact that you're not protecting it. So Disney needs to, whenever they find out that some daycare center is using Donald Duck on the wall, they need to respond to that. Otherwise, they are implicitly saying it's okay for anybody to use the image of Donald Duck. So that's just kind of, it's not always evil. I just have to do that in order to defend my intellectual property. The other kind of legal or protection that you need to have is to avoid coming to the common usage, and this is kind of what you were referring to earlier. You can be so good at branding that the brand becomes the category exemplar, and if it actually becomes the category exemplar, you could lose the branding because people would say it's the name of the product. For example, aspirin used to be a branded product by the Bayer Company. Escalator was a brand name of a moving staircase. They lost those because it became so common. So again, the way that you avoid that is you, one, avoid using it as a noun or a verb, and you always make a distinction between your product and the brand. So Band-Aid is a product that is in danger of losing It's protection because the Band-Aid name is pretty much, so anytime you hear communications from Johnson & Johnson about their adhesive strips, it's always Band-Aid brand adhesive strips, not Band-Aids. Don't put a Band-Aid on it, but Band-Aid brand adhesive strips. Kleenex brand facial tissue, not a Kleenex. Don't give me a Kleenex. So Xerox brand copiers, you don't Xerox. So you don't use it as a noun or a verb. You use it as a modifier of a noun or a verb and make the clear distinction between the brand and the product category in your advertising. Again, that's only a problem if you're good. If your brand stinks, then nobody's going to worry about it's going to become the generic name.